3, 2, 1, start. Aggrieved by and dissatisfied therewith, the appellants filed an intra-court appeal, being Special Appeal Number 103 of 2004, which was disposed of by a division bench of the High Court, giving liberty to the appellants to make a representation to the concerned authority within 10 days with a direction to the authority to dispose of the same within 3 months thereafter. Before adverting to the rival contentions raised by the parties, we may notice that according to the appellants, even today there exists two vacancies. The purported chart prepared by the appellants and the records placed before us show some discrepancy. At this stage, it is not possible for us to go into the details thereof, particularly when the candidates already appointed are not parties before us. The select list was prepared in the year 1998. In our opinion, it would be difficult to issue any direction for appointment of the appellants herein at this stage. Select list was prepared keeping in view the rules as they existed. The said rules might have been declared ultra vires, but as indirected herein before this court in exercise of its jurisdiction under Article 142 of the Constitution of India, though it fit to give a prospective effect thereto. It did so inter alia for the purpose of protecting the services of those teachers who had already been appointed and had been in service for a few years. Out of 10 posts, 8 teachers were appointed on or before 18th November 1999, which was the cut-off date. The question as to whether the fresh appointees who are having regard to the said modification required to be appointed on the premise that they are placed higher in the select list than the appellants or not, in our opinion, cannot be gone into by us for the first time, since such a contention had never been raised before the High Court. The entire record of the matter, furthermore, are not before us. It is stated that 2 appointments were made in the year 2003, one against OBC quota and another against general quota. It is not possible for us to go into the question as to whether the entire quota for appointment in the category of OBC was filled up in the year 1989 to 1999 itself, and thus appointment made against the vacant posts from the said quota is illegal or not. The concerned respondents are not parties before us. We have not been informed as to whether any other person has been left out from the original merit list. Furthermore, the select list would ordinarily remain valid for 1 year. We fail to understand on what basis appointments were made in 2003 or subsequently. Whether the validity of the said select list was extended or not is not known. Extension of select list must be done in accordance with law, apart from a bald statement made in the list of dates that the validity of the said select list had been extended. No document in support thereof has been placed before us. It is seen that verification of the character and antecedents is one of the important criteria to test whether the selected candidate is suitable to a post under the state. Though he was found physically fit, passed the written test and interview, and was provisionally selected on account of his antecedent record. The appointing authority found it not desirable to appoint a person of such record as constable to the disciplined force. The view taken by the appointing authority in the background of the case cannot be said to be unwarranted. The tribunal therefore was wholly unjustified in giving the direction for reconsideration of his case, though he was discharged or acquitted of the criminal offence. The same has nothing to do with the question. What would be relevant is the conduct or character of the candidate to be appointed to a service and not the actual result thereof. If the actual result happened to be in a particular way, the law will take care of the consequence. The consideration relevant to the case is of the antecedents of the candidate. Appointing authority, therefore, has rightly focused this aspect and found it not desirable to appoint him to the service. In Kendriya Vidyalaya Sangathan versus Ram Ratan Yadav, All India Rank 2003, SC 1709, Honorable Supreme Court examined a similar case where in the employment had been obtained by suppressing the material fact that criminal proceedings were pending against him at the time of appointment. The court rejected the plea taken by the employee that the form was printed in English and he did not have good knowledge of that and therefore could not understand as what information was sought. The apex court held that as he did not furnish the information correctly at the time of filling up the form, the subsequent withdrawal of the criminal case registered against him or the nature of offences were immaterial. The requirement of filling column numbers 12 and 13 of the attestation form was for the purpose of verification of the character and antecedents of the employee as on the date of filling in the attestation form. Separation of material information and making a false statement has a clear bearing on the character and antecedent of the employee in relation to his continuance in service. The Honorable Apex Court further held that there has to be a deliberate and willful misrepresentation, and in case the applicant was not aware of his involvement in any criminal case or pendency of any criminal prosecution against him, it cannot be held that he made a misrepresentation. In the said case, the information sought was as to whether he has never been arrested, as the applicant was wanted in a criminal case and he has got a stay order from the court. He furnished the information in negative. The Honorable Supreme Court held that it may be a case of mistaken impression but not a deliberate impression.